Thank you so much. We're gonna go around the table and introduce ourselves. My name is Maricela Cano and I'm the clerk of court for Boulder.
My name is Megan Kane. I'm a supervisor in the clerk's office.
Hi, I'm Danielle Riccio, a supervisor in the clerk's office.
I'm Debbie Beck. I'm a district court supervisor.
And I'm Melissa Johnson. I'm the county court supervisor.
And I want to just take a few minutes to go over just some general instructions of how we're going to conduct the meeting, just so that we do this timely. We're going to, as Kyle mentioned, I have other duties assigned this afternoon, so I have to stop the meeting at 3 p.m. After each section of the meeting, we can pause to see if you guys have any questions. In the meantime, if you do have questions, you can either pop them into the chat and either Megan will alert us to answer the questions, or she'll, give an answer via chat. And then after we're done with the agenda items, we'll also try to pause or at least leave some room at the end to ensure that if there are any other questions that you want to ask of the group, that you can do that at that time. So we'll go ahead and just get started with one of the first agenda item, which is the document processing. This stems from a question that was submitted of, what we look for when accepting and rejections of documents.
So I'm just going to cover that a little bit. We have two directives that really drive when we are looking at accepting and rejecting documents. One is a local administrative order that can be found on our website, which is
I didn't do anything.
03-106. And the other one is our Chief Justice Directive, which is 11-01. I think the Chief Justice Directive is one of the most helpful things to review when trying to determine how we look at accepting and rejecting documents. There's a few different pages that address how things should be filed. Jury instructions, exhibits, how to title documents, but there's also you probably can't see it very well, but there's a little table in the back of that Chief Justice Directive that gives our reasonings for why we reject items. And some of the other supervisors can chime in, but I think that for me, a lot of the things that I see when I'm rejecting documents are documents that aren't filed into the wrong case. Because we do have Boulder and Longmont, and we share case numbers, it's easy sometimes to be filing into a Boulder case when it really should be a Longmont case or vice versa. So just making sure that you're filing into the right court location with the right case number on it. Also making sure that any proposed orders are in an editable format. We get quite a few documents and orders that are in PDF, and if it's I think a good rule of thumb is that if it's something that the judge is going to be reviewing and issuing, it should be in an editable format so they can make any changes that they would like to make. And also we do see cases where it includes the metadata. So if you've gone in and done some edits, sometimes we have filings that come through with those edits still showing. So your redlined documents, and of course we're going to reject those because we can't accept those documents.
Yeah, I think you went through and covered. Do we have any questions in the chat, or does anybody have any other questions pertaining to the document processing?
I don't see anything in chat.
Okay. Danielle, you want to take it away with evictions?
So I'm just going to cover the eviction process according to our admin order we have here in Boulder, which can be found on our Boulder Court website. It is 20-108. So here in Boulder, our admin order, we want our FPD cases filed by Wednesday for this admin order for the following week docket. In Boulder, we will take up to 65 cases on the Boulder docket and up to 25 cases on the Boulder Longmont docket. 15 of those cases here in Boulder can be pro se cases, and then the other 50 can be law firm cases, and a law firm can file no more than 30 cases per week here in Boulder. And over in Longmont, they is 5 pro se cases, and a law firm over there in Longmont can't file more than 10. We do require in when these cases are filed, that the summons does come in with this case type. So we can verify the date that you want on the hearing. We also want to have the lease, if there is a lease, we want to have the demand or the notice to quit that was issued. So we can verify that the proper time was allowed for that filing. Then we also want to see if there was a 30-day notice, if there was anything for cares or anything like that for the defendants, and mediation was followed per the new House bill that came out. And here in Boulder and also in Longmont, we do have our mediators here on the day of court. So, and we also have here in Boulder, Bridge to Justice here to help all the defendants. So just be prepared to work with the defendants and the attorneys here.
Is there any questions pertaining to the eviction process that you would like for us to answer? No? Okay, well, you guys are making this very easy, so thank you. So we'll go ahead and move along. I would like to share my screen with you guys, and what I'd like to do is show you where to find some of those administrative orders. And the reason for is because not only will you be able to let's see where you can locate them. Can you see that? Yeah, perfect. It's easy for you to go in and kind of review the either CJD or administrative order pertaining to a process or procedure. I know sometimes, you know, you guys might be working through something and just need a quick answer. Based on staffing right now, most of the supervisors are either covering dockets or covering front counter or various other duties. So we're not at our desk as readily available as we used to be. So this is a good way for you to know where to locate these administrative orders and pinpoint and try to get those questions that you might have answered. So if you go to our website and you just go down in here, there's this information for attorneys. And here you're going to find all the Chief Justice directives. And as you can see, they're in there in by year in numerical order. One of the ones that I think Megan was talking about is CJD 1101, the statewide standards. So if you just click on it, it's going to pull right up for you. And one of the good things about this is if you're scrolling along and reading through it, if you're having questions about like the document size, there's links in here that you can just click on and it'll take you to some of the F, A, and Qs. And then you have your answers, whether it's what kind of payment options are available, or can courts reject filings and things of that nature. So that's one of the things that I, as an employee of the courts, tend to utilize quite often is our CJDs and our admin orders. Let's see, maybe is it not going to let me go back? Okay. For our local administrative orders, you just have to search by county. And you have to go, once you're in our 20th Judicial webpage, you'll have to click on the business resources and the general information to get to our administrative orders. You'll have all of the administrative orders that pertain to the 20th Judicial District listed here. including at the very top, you'll have, and I'm sorry for those of you that have motion sickness, my scrolling through fast. At the top, you'll have your index of the administrative order, so you can always reference that. And I'm going to scroll again. I apologize for the fast scrolling. One of the ones that I tend to utilize a lot when I get phone calls is our Exhibit 1, because a lot of people will ask, you know, how do I number the exhibits? Where should I number the exhibits? This is a good way to identify how plaintiffs and petitioners should identify, or how they be numbering their exhibits versus the defendants and respondents. But here's something that always gets missed, and it's mostly pertains to when submitting audio, like a CD, a DVD, or a flash drive. One of the things that I always encounter is people will send carriers to the front counter windows with their exhibit to be submitted. It talks about a notice being filed. You have to, as a law firm, you have to let the court know that you're going to be submitting a CD or a flash drive. So you have to e-file the notice first. Then when you send whomever to drop off the CD or the flash drive at the front counter, you have to ensure that they have a copy of that notice with them, because it's one of the first things that we're going to look at. I think I spend more time trying to point that out to people that send carriers to drop off their stuff. But this is one of the things that I will always do, is I will send them back, or I will email people, and it just states right here that that's one of the requirements, that the notice should be e-filed into the case, letting the court know that there's going to be an audio or video submitted to the court, so that when people show up at the front counter to drop that off, we're well aware of it. The other, I think those are the main two administrative orders that I wanted to show you, because I think it tied into the questions that were submitted. But if you are looking for practically anything, I mean, as you can see, the list is pretty long here of the administrative orders that we have that pertain just to our local district. Does anybody have any questions, or is curious about any other administrative order? Okay. And I'm gonna pull up CJDO 501 that talks about what Megan's gonna talk about next. So let me get there. Apologize for the scrolling. Sorry. Let's see. Is it page 6 that I said?
Page 6.
Okay.
So we did have a question regarding document security, which I'm sure if you're all e-filing, obviously you guys have the option to pick those different security settings, and we do have a few. So as Monty said, she's pulling up the Chief Justice Directive 0501, which is concerning access to court records. And on page 6, there is a section that talks about all the different ways documents can be filed and what those definitions are. So sealed court record, a suppressed court record, a protected court record, and a restricted court record. And they give a really nice definition under each one on that page 6, but a sealed record is only going to be viewable or accessible to judges, court staff, and other authorized department staff. So if you file a document sealed and then look in the case later, you are not going to see that document because it is only going to be available to court staff. Suppressed court record is going to be any court record that is accessible only to judges, court staff, parties to the case, and if represented, attorneys or other authorized department staff. Protected court record means any court record that is accessible to the public only after redaction in accordance with federal statute or regulation, state statute, court rule, or court order. And with a different section of this policy. One of the best examples I have for that is if you're entering, or if you have an attorney who's entering their appearance, like on a traffic matter, sometimes if they just want a copy of it and they haven't entered, so they're not a party to the case, and they ask us for a copy of the ticket to see what the person's being charged with, those are protected documents because we do redact information from those tickets. If there's a social security number on there, if there's a driver's license number on there. So it's certainly a protected document, is something the public can have. They just have to, we have to review it for redaction first before we can release it to someone who's not a party to the case. And then restricted court record. This is a court record in a criminal case that includes a charge of either a sexual assault or involving a child victim. So before it can be released, any victim identifying information has to be redacted. Otherwise, it's just accessible to judges, court staff, parties to the case and their attorneys, and other department staff, as well as all criminal justice agencies. So again, it doesn't mean that the public cannot have the document. It's just certain information would need to be redacted, including the victim information for those particular case types. So this is a really good resource to go to if you have some questions, if you're e-filing a document or unsure of what protection you should pick for that. We do have some items, I think, that automatically default to either a protected item or a suppressed item, but if you are submitting something that you know has confidential information on it and you're not sure how that should be filed with the court, this is a really good resource to check in with.
Any questions pertaining to the security of documents? It looks like there's one chat.
I think it's on images that really helpful to see where to access these directives and orders. Thank you.
Oh, perfect. I'm glad it was helpful. So I am going to stop sharing my screen because it looks like we're getting to the questions that were received. I think we answered a couple of them already, just based on the conversations that we were having about the process itself. I'll read the questions, and if somebody needs further clarification, please let us know. One of the questions that was submitted is, how does the court prefer certain documents to be titled? I think for the most part, everything has a drop down. So if it's a motion to dismiss, select that. If it's a motion that's not within the drop down, you can certainly title your motion or request or response with the title and the caption. The other question was, what are frequent things that cause rejections? And I think Megan talked a little bit about that. I'm not sure if there's a specific question or example that somebody wanted to share that you thought something shouldn't have been rejected and was rejected. We can certainly answer that, but I believe that question was answered. The other question that was submitted was, does the court have preference on where to stamp exhibits? I don't know that there's a hard rule. What I would say is, if it's visible, if you're going to stamp on the top right, then just be consistent with it. I think some people do it on the top right, some people do it on the bottom right. Consistency is probably key. Let's see, next question. Filing complaint preferences, does proposed summons need to be filed too? I think it depends on the filing, but anything in civil that you
We need to see, this pertains really to county court, civil. We need to see the summons on FED cases, and we need to see the summons on civil return cases, because we need to verify the civil return dates and the FED date, that they are in compliance with our dates that we hold the hearings here in Boulder.
Okay, and the last question that was submitted was the difference between serving versus filing. I'm not exactly sure what was meant by that. The only thing that I can guess is if if you're filing something with the court, is that considered serving? I don't think necessarily. I think you have to follow the rules for serving, for process, process serving. I can tell you one thing, that if the court sends out a copy of a document, it's not technically served. Or if you submit it to the court and the court then forwards something to the other party, that's not considered served. As court staff, we are not able to serve as a serving party. I know that question has come up in like DR matters in past years. So if that's what people were referencing, then there is definitely a difference between serving and filing. If
I just want to say though, if you are filing in for civil cases, if it's disclosures or discovery that the court does not need, please just make sure you are just serving those out and not filing and serving those, because the court does not need that part of the record.
I think that's all.
Okay. Does anybody have any other? Can you repeat that? Can you repeat those?
So on like district civil case, I'll just use district civil for an example. I know on like the big disclosures that get filed in, the disclosure notice is fine to be filed with the courts, but all of the attachments to that disclosure notice, the court does not need that as part of the record. So when you are filing those out maybe to the other parties in the case, just make sure you're hitting that service out to the parties and not a file and serve. So we're getting all of those attachments to the courts, because that does not need to be part of the record. And I believe that is also part of e-filing duty.
Did that answer your question? Yeah, I think she said thank you. That was the end of the list that we had of questions that were submitted. If there's additional questions, you can either unmute and ask your question, or you can submit it or put it in the chat, whichever is easier for you. We'll try to answer as many questions between now and 3 o'clock. It's now 2:24, so we have a little bit of time if people want certain questions to be answered. Not seeing any. Are you sure? Because getting us back on in the same room on a Zoom meeting is going to be difficult. Okay, no questions. How about comments? Is there something? Is it a proposed order or just order? If you're submitting something, it has to be a proposed order. The actual order comes through when the judge rules.
I think maybe what she was meaning with the question is like when we're submitting stuff and we're filing it, do you want it titled proposed CMO or proposed order to dismiss or whatever it is? Do you want the proposed in front, or do you just want the drop down arrow for proposed order and it just to say order for?
So on the event would be proposed order, and then on the document title line, just type what the order is. We don't need the word proposed in the document title line.
Okay.
And then Danielle, do you want to answer? Can you go over best practices for filing a new action in county court?
On a money case, or what type of case?
Allison, what type of case are you referring to? Just generally, she says.
So it's generally, we see in county court here, mostly FEDs and money court cases filed. So on the money court side of things, typically we see the summons and complaints filed with a civil return date here in Boulder for a Wednesday afternoon at 1:30 p.m. No more than 9 weeks out. And the complaints filed, we don't need a return of service filed at the same time, but we typically do file and serve ahead of time. On those cases, we do here in Boulder want the proposed judgment tab filled out when filing a civil return case or a money demand case here in Boulder. For the FED cases, then we expect, or we would like to see them filed no later than a Wednesday, 10 days in advance of the hearing date that you would like. They'll be doing Fridays here in Boulder, not at 9 a.m. if they're being filed by an attorney. We'd like to see the summons, the lease, the demand notice, and the complaints, along with the proposed writs filed in on those cases. In Boulder Longmont, our civil return date are Friday afternoons at 1:30, and FEDs are done at 10 a.m. on Fridays.
I'm sorry, I'm just reading this question.
That's fine.
So I would say that when you're submitting documents, if it's been titled the actual document as an opposed motion, as an unopposed motion, that's how you can put it in the title. If you don't use unopposed, I would just title it the way it's actually titled in your motion. I don't know, Emma, if that was your specific question. Sometimes we do see, like, this is a good example. If you're filing a motion for your client to leave the state, there isn't a specific motion to leave the state. So you would just have to pick motion. However, on the title, it's helpful for us for them to say motion to leave the state, or however your attorney or you have captioned that actual document. So we know exactly what it is. That way, when we accept it, the judge can also see in the case and in their inbox exactly what that is. It's a motion. It's a motion to leave the state. They pull it up, and that matches what the actual document says. Any other questions?
I had a couple more questions for you guys. So I was the one who had submitted the question about the serving versus the filing. And I don't mean like serving a defendant. It was more the action of serving through ISIS or CCEF versus filing to the court. And you guys addressed it a little bit, but I kind of wanted to water it down in case there was anybody that was new to filing. And I know in the past, like if I've filed like a statutory offer of settlement with the court, it gets rejected because it's supposed to just be a serve only. So I was just wondering if we could maybe just touch on some of the primary serve only. I know we already said disclosures and like written discovery, but I didn't know if there were any other major documents that you see come through often that should only be served to the parties versus filed with the court.
You know,
I think the big ones are the
disclosures.
discovery, and those settlement documents in district civil are the big ones that we see.
Yeah.
Are there any pet peeves when certain filings come through that you look at and you're like, ah, this again? Anything that we should know of?
I think the biggest thing for, on a district civil standpoint, I think the biggest thing for us is that if you are filing in a complaint or an order and it's like really long, we would like to have the whole, in the document title line, we would like to have the whole title put in the document title line along with the order, the proposed order, that whole title put in the document title line. Because if it's not there, then we have to type it in when we get it before we accept and file it over to the division.
Okay. So speaking of like the longer filing names, when we are filing affidavits, how descriptive do you want us to be? Like return of service or affidavit of service on defendant so-and-so on this date? How much do you want us to add?
So we would like to see a minimum return of service. If it's on the defendant, on whatever date it is. If it's to return of service on wife or defendant on this date. Like who was served, if it was on behalf of the defendant and on the date.
I think that's it for me.
I don't know if that's Sarah's question. That may be a question for Danielle.
So, can you see the question? Or do you want me to read it to you?
I can't see.
Okay, Sarah submitted a question. There was a question in the chat about why is there and submission option to submit to the court and do not submit to the court served selected. Isn't it the same thing as the serve only option? I think we're having a hard time understanding the actual question. Are you saying that there's a submission option to submit to the court or to not submit to the court?
Yes, hi. In like, so I'm in like the court filing, and in the beginning, when you like pick your case, it has like the serve only or like the serve to file. Sorry, I don't know the difference. And then like when you're about to like check out and like actually submit it, it has like submission option, and it says like do not submit to the court, and then submit to the court. But it says like no service party select. Like I just don't know what that means.
I think we're having a hard time understanding it because we don't see the same thing that you see when you're filing through CCE. Sorry.
Oh.
Yeah, when it comes over on our side, it looks different. It just pops into our court system, which looks slightly different than what it looks like for you. So I think that's why we're having a hard time. I'm assuming what they're asking you, if you want to, once you're in there, if you actually want to submit it to the court or not. But again, I'm just guessing on that because I've never seen the side that you see.
Got it. Okay, maybe I'll take a screenshot. It's like really still confusing me, but it's okay. Thank you.
No, yeah, and if you take a screenshot and you want to like reach out to us to help you answer that question, we're happy to do that.
Okay, appreciate it.
Yeah, of course. And then what was the next question? Do you have any must-know tips for paralegals beginning their careers? Do you guys have any tips? I think that what I would just say is just getting familiarized with some of the instructions on how to file things on our website is probably helpful, because that's something that when I talk to pro se defendants, I say, you know, our instructions for each case type are pretty detailed. So it's kind of nice to visit those and get familiarized with them, because then that way it might help you in your process in building your career, just knowledge base. And then let's see, there's another question. I think it was a comment regarding the, says, I think it means the same thing, the initial serve only adjusts to the options for serving and takes out a lot of the documents that have to be filed. And then can you just adjust it again at the last submission page? It doesn't seem, those are comments, not questions. Any other questions that people might have? We still have about 20 minutes, so we can do a few more questions if you guys would like. Okay, going once, going twice. Yes. Proposed order submit with RE, yes.
Order.
Order.
Order and type. So if it's like a proposed order for default judgment, then you can just title it order for default judgment. Another quick thing I was just going to mention as well is with the rejection of documents, we try to pick a category that matches the reason why we're rejecting it, but every once in a while, if there's something there, if it's a little unusual, we try to add a comment. And so if you do get a rejection and you're not sure why, and you're not sure based on the option that we picked for why we rejected it, to take a good look at the notification, because we do try to put in a note to make it a little bit clearer why we were rejecting that document. So if you're not seeing a note and you still have questions, there is a number that comes up for you to call the person who rejected it. But I do let people know that I usually try to add a note if it's not super clear what I'm seeing and the reason for why I'm rejecting it, to give the person an idea of why we sent that back.
And I believe that our phone numbers, whoever rejects the document, I think the notice that goes out to the party also will get an indication of who rejected it, like the name and the phone number that they can call and contact that person. So if their comment is not specific, or you're having a hard time understanding their shorthand, then certainly call the person. If for some reason you can't get a hold of them, or you try to call them, call our main line, and then you can have somebody transfer you to them, so that you have a clear understanding of why it was rejected.
That's his question. I'm not sure that they do that. That might be a question for CCEC.
What is it?
What is the best way to get notifications for a pro se party that filed something? Do they get notified?
I don't think you get notified, at least not through the filing system. As far as I know, it doesn't notify.
Yeah, you might want to call CCE, because I don't think that when pro se parties file something, usually they're filing directly with the court, so we just upload it to the case.
And I think, to clarify Allison's question, I think she's asking for when they file their proposed order, should the title be order regarding or just regarding? And it should be order regarding. Yeah.
You're welcome. Any other questions? Well, I would like to, since I don't see any other questions, I want to take just a couple of minutes just to thank Carrie and Nina for reaching out to the court, putting this together. I think that it's good that there's some type of connection, just so that you get to know who we are and we get to know who our public is. Please don't hesitate to reach out to any of us if you have additional questions. As I mentioned, we are short-staffed training new people, so we don't spend as much time in our offices as we used to. So if you leave us a message or send us an email, we might not get to you right away, but we do try to respond. And then, just thank you for your patience. I know sometimes people file things with an urgent matter that gets filed last minute. We try to docket that most of everything that comes in the next day. However, it's been tough these past few months. So we appreciate everybody's patience and allowing us a little bit of leeway because we don't always get to those filings the next day right away.
Thanks, Emma.
Thank you, Emma. Thank you for joining us. Thanks again to Nina and Carrie for putting this together. We appreciate it as well. So thank you, everybody that took time out of their day to attend during, I'm sure, a busy day as well. So.
And I just want to say thank you to the court supervisors for switching to Zoom. So it made it easier for us to record, and we'll make this recording available to the paralegal section members. So if there's anything you want to review, or if you came in a couple minutes late and missed anything, you'll be able to review that. And I'll get the recording link out to everyone as soon as possible.
Thank you, Kyle, for facilitating the meeting. We appreciate it.
Absolutely. Yeah, and if you need anything or are trying to get in communication with anyone, one way or another, court reporters to paralegals or vice versa, feel free to contact myself, Nina, or Carrie, and we'll do our best to facilitate that communication. Yeah, people are just thanking. I guess you got all the questions answered. So very good job. Thank you, everyone.
Thank you.
Absolutely. Have a great day.
You as well. Thank you.
Bye.